So good afternoon, everybody, and thank you for joining us in this afternoon for this webinar. Subject is the new penalty protection regime for hybrid cases according to the Italian law. As you all have the agenda of this webinar. So before spending a few words of introduction, just let me give you some, let's say, preliminary, service information. First of all, the fact that the slides will be presented today will be available, I think, as from tomorrow on our website. So you can download them from the website as from tomorrow. Second, that the webinar will be video recorded, and the video recording will be available as well on our YouTube channel. I think that's from tomorrow or the day after tomorrow. I'm not sure about that, but in the next days. And last but not least, the service information. So if you have any questions that may arise during our presentations, you can use the section Q&As that you can find inside the Teams, and we will see also all the questions that may arise from you, and we will collect them and answer at the end of the last sections of the webinar, so in the Q&A sections. So going back to the introduction, so just a few words regarding the history, and we'll make a very long story short, just to understand why we are here now today, and the reason why we're talking about this new Italian legislation. So we have to go back to the let's say 2015, 2014, 2015. So we have to go back to the BEP project and Action 2. So within the BEP project, there is a huge project regarding neutralizing the effects of the mismatch arrangements, and that led to two OECD reports. So the one that was issued in 2015 and in the second in 2017, both related to this argument that led to the directives, the EU directives, so this called ATAD directive, so the anti-tax avoidance directive, so the ATAD 1 and ATAD 2, that so they are dated to 1164 in 2016 and 952 in 2017, that were, let's say, then implemented in Italy through the legislative decree 142 of the year 2018, where the specific legislation regarding the neutralization of the effects of the hybrid mismatch arrangements was introduced. So that's Article 6 to 11 of this legislative decree. This legislative decree was firstly commented by the Italian tax authority, so by the Revenue Agency, with the circular letter number 2 of 2022, and with a lot of examples. But we will, my colleague later on will enter in a lot of details regarding these points. I just want to focus on paragraph 6 of the circular letter, which comments Article 11 of the ATAD decree, of this legislative decree. Why Article 11? Because Article 11 is important because it provides a specific procedure of assessment in case of assessment related to infringement of the provisions regarding neutralization of hybrid mismatch. And it says that, let's say, when the tax authorities want to do an assessment regarding hybrids, that they must made it by a specific act that have to be proceeded, under penalty of nullity, by the notification to the taxpayer of a request of clarifications to be provided within a period of 60 days. What does it mean? It means that it was introduced, it already existed in some specific cases in the past in the Italian legislation, and this, let's say, right to be heard in advance. So a right that, as from 2023, has been, honestly speaking, generally introduced in the Italian tax legislation by the legislative decree. So there was 219, it was issued, let's say, at the end of 2023, when a reform of the statute of the taxpayer's right was introduced in Italy, and where this principle was introduced, so generally for all the tax assessment, the fact that before issuing a deed of assessment, a specific draft deed has to be preliminarily issued by the tax authorities, and based on this, the taxpayer has the right to be heard in advance to provide his comments. So, and only after that, so this 60 period where there is this possibility for the taxpayer to explain his reason, can be issued the deed of assessment. So this, I mean, this provision, which now is generally, let's say, applicable to in all cases, was specifically introduced as from 2018 for the hybrid cases. With a technical specification due to the fact that in this case the penalty is a nullity, and in case of the general new rule is an annulment. So there is a small, but not it seems a small difference, but it's from a technical point of view it's important. But apart from them, what's interesting to say, so in regarding what the tax authority says regarding the comments on Article 11, is that is the last sentence that is represented in the slide. So the tax authority says that a good tax risk management practice for taxpayers is to carry out, prior to the filing of the tax return, appropriate analysis regarding the existence of any relevant hybrid mismatch, also by requesting the cooperation of associated enterprises in order to establish suitable supporting documentation in advance. So what does it mean here? It means that at the end of the story, it's important that the taxpayer provide supporting documentation to his activities, and to strengthen this principle, we arrive to the new legislation. So Article 61 of the legislative decree 209 end of 2023, which introduces paragraph 6b of the legislative decree 471 1997, which introduces this penalty protection regime. So penalty protection regime, very similar, I would say, almost, let's say, from the TP documentation penalty protection regime, which states that if the taxpayer delivers to the tax authorities a documentation which has specific criteria, and we will discuss, the colleagues discuss later on about this. So the criteria that to be met to be considered this documentation appropriate, that has a certain date, and this documentation is adequate, suitable to allow the verification of the application of the rules aimed at neutralizing mismatch, hybrid mismatches, then in this case, even if there is a case of assessment of contestation, then the taxpayer is granted with the penalty protection. This is where we are now. There is a last step, and the fact that the law provides indicated that a specific decree by the Minister of Economy and Finance has to be issued in order to specify this criteria we will talk about later on. Then this specific decree was issued at the beginning of December 2024, so on the 6th of December 2024, indicated all the criteria. And so now we are here. So we have this new regime applicable, for 2024 and then the following and the previous year as well, but we'll talk about later on in detail. And so that's the reason why we're here now. So just very, very quick presentation, just introduction. And I leave the floor to Guido Donello, my colleague, so we'll go on more detail in the regime, give us the summary of the regime, and then also our colleague later on will enter into detail. So Guido, it's up to you now.
Thank you, Luca, and thank you all for joining. Let's say that, as Luca said, we are now talking about a law provision that entered into force in 2018, as you heard from Luca, but we have now a new regulatory framework in terms of documentation. And this is why we are talking today about the documentation for anti-hybrid purposes, because let's say, finally, the Italian government, with the legislative decree 209 of 2023, introduced the penalty exemption regime for the transaction generating hybrid mismatches, but only in early December 2024, the implementation rules were introduced. So we are in front of a, let's say, legislation based on the, let's say, international general set of principles in accordance with the ATAD directives, but the legislative framework, the Italian legislative framework, has been completed only early December 24, with the issue of the provision for the documentation necessary to gain the penalty protection regime. We experienced it in the last few months, quite an aggressive approach by the Italian tax police and the Italian tax authorities towards the hybrid mismatch topic, and we experienced extensive audit activities on the M&Es focused in, let's say, trying to find hybrid mismatches in the intercompany transactions incurred by the Italian, mainly by the Italian subsidiaries and the mother companies, or let's say other group companies. And this is focused mainly on the entities of the groups taking part in financial transactions, but also in transactions involving the use of the IPs and the management of the IPs in an intercompany M&Es framework. This is very important because led to the issue of very important tax audit reports, mainly focused on these type of transactions, and in some cases having a very big effect in terms of additional taxable basis, and in some cases additional taxable basis equal to the cost of goods sold by the Italian subsidiaries, mainly in the case of an Italian subsidiary taking the role of mere distributor. This is why, in our opinion, it is very important now to discuss this topic and to take also a fair position on the documentation side, because the penalty protection in such a case is very important, because the effects in terms of additional taxable base and additional taxes, corporate taxes, are very huge, and also the penalties, according to the Italian law, are very high, ranging from 90% to 180% for the tax years under investigation by the tax authorities. Let's say, as a general comment, and I take the opportunity to go to the next slide, that the Italian tax authorities took quite, let's say, an aggressive approach only in the legislative framework. This is because, according to the Italian tax law, the hybrid legislation is, let's say, effective starting year 2000, but only also with regards to the effects generated by, let's say, transactions, extraordinary transactions or whatever transaction that was effective in the prior years, and this is something to be regarded very careful when you need to prepare the documentation for anti-hybrid purposes, but also when you analyze all the intercompany transactions in global environment. But before taking, let's say, further details in this respect, let's introduce in very, let's say, short terms, what is tax hybridity? Tax hybridity needs, let's say, three requirements, tier 3 basic elements to be met. The first one is for sure the asymmetrical tax treatment of, let's say, a tax relevant event. And this is, let's say, relevant in connection to, and this is the second requirement, to entities in terms of companies, permanent establishments, or legal transaction, or item of income. So both the entities, how they are structured in an M&E's environment, and the items in terms of items of income, or also legal transactions in terms of agreements and also structured agreements. And the third requirement, these transactions needs to be capable of generating inconsistent tax effects in terms of mismatches at international level. And this is the key point, because notwithstanding, let's say, the group structure and the existence of the transaction, we need to investigate the inconsistent or the potential existence of an inconsistent tax effects between different countries and different tax systems at the international levels. The average mismatch typically is a double deduction effect or a deduction without inclusion. Let's say, introduce these two key topics that will be then, therefore, further investigated by my colleagues after me. First of all, the deduction without inclusion is the deduction of a negative component of income in any jurisdiction in which is incurred or expected to be incurred, so in the jurisdiction of the payer, without the corresponding inclusion for tax purposes of the positive component in the other jurisdiction, or better, in the jurisdiction of the payee. So the payer deduct the negative component that is not taxed in the jurisdiction of the payee. This is the deduction without inclusion. Or in the form of a double deduction, that is the deduction of the same negative income component in the payee jurisdiction and the payer jurisdiction. And in this respect, you have, let's say, a negative tax relevant income component deducted double without any inclusion. This is a typical, let's say, scheme mainly for the financial transactions. And it is very, let's say, regarded as very harmful by the directives and also by the Italian implementing legislative scheme. Let's go to the next slide, where we have the, let's say, definition of the phenomena that could be or can be the mismatch for direct hybrids or the mismatch from imported, the so-called imported hybrids. So this is, let's say, a key, let's say, definition and the key characterization of the relevant transactions And this is because also for documentation purposes, we need to take different analysis and positions if we are in a direct hybrids environment or in an imported hybrids environment. This is because the Italian implementing rules provides for different information and a different schema and proofs for these two different type of phenomena. Let's define them. The first one, the mismatch from direct hybrids, is the effect of deduction without inclusion or double deduction generates the hybrid mismatch if the following conditions are met. The two conditions are the subjective element, that is the Italian taxable person is the payer or the investor or beneficiary. So here the key role is played by the Italian taxable person. We need to look at, first of all, the Italian taxable person. And then the second condition is that the transaction, the tax relevant transaction, must have a hybrid nature. So the investigation at two levels. First one is the subject element, the Italian company, the Italian payer, and the second one is the hybrid nature of the transaction. What about the imported hybrids? Imported hybrids are not involving a direct effect on the Italian entity in the sense that you are not capable to intercept and to look at the hybrid transaction looking only at the Italian entity or the payer. Because this is because it presupposes the existence of a direct hybrid not involving the Italian payer, so the Italian entity directly, but involving other entities inside the group, but the effects of these direct hybrids are transferred to a series of payments to the foreign enterprise that triggered the hybrid mismatch. So basically you have a direct hybrid effect between foreign entities, but the Italian entity takes a role in this because it is financing the direct hybrid. Just to give you an example, if you have a relevant transaction between foreign entities involving IPs, where a royalty is included in one country, but is double deducted or is double deducted without inclusion, and you have the Italian entity taking the role of limited risk distributor in Italy, purchasing the goods from one entity, taking part in the direct hybrid, then you have the Italian entity that is financing the direct hybrid through the payment of the goods sold in Italy. That's basically the difference, and the most relevant, the most triggering one is the imported hybrids, because here you do not have a direct involvement of the Italian entity, and you need the support and the collaboration of the group in order to intercept the existence of such transactions. Now let's go to the effects of the penalty protection. If you have both direct or indirect hybrids, both direct, imported, or whatever hybrids, you can take an important effect, that is the penalty protection, by, let's say, preparing a proper documentation file for anti-hybrid purposes. This is, let's say, an important effect because if this document is prepared in accordance to the guidelines set by the Italian tax authorities, then you have a complete, let's say, penalty protection regime for incorrect tax return. And this is quite a huge effect in terms of numbers involved, but also on indirect effects in terms also of criminal responsibilities for the directors of the Italian entities preparing the documentation file, which is the process for, let's say, having this important effect in place. You need, as I mentioned, to prepare the documentation, and the documentation must be a digital document with a date, an official date, resulting from a stamp time that is an official timestamp on the document in order to give it the official, let's say, date in which it has been prepared. And the documents must be suitable to demonstrate the concrete application of the rules to neutralize the arbitrary mismatches. This is because the Italian legislator take a very, let's say, an approach in preparing the documentation file that is focused on the procedure. You need to disclose mainly the procedures that are taken in respect of the transaction, the potential hybrid transaction involving the entity, the Italian entity preparing the documentation. This is because they need to look at the approach to the problem and which steps are followed in order to demonstrate that an hybrid is in place or is not in place. The prior communication, you need to notify to the tax authorities the intention to make use of the option to prepare the documentation by filling a special section of the tax return form. So, in general terms, as a general rule, if you prepare the anti-hybrid documentation, you need to file let's say, a special section in the tax return. This means that the, let's say, natural, the ordinary deadline for preparing the anti-hybrid documentation is the deadline for preparing the tax return for each tax year. The delivery, the documentation is at the request of the tax authorities during assets inspection or verification or other investigative activities. So basically, you do not need to transfer immediately with the tax return the anti-hybrid document, but you need to provide in a very short timeline, 20 days, the full document set to the tax authorities in case of audit. Let's go finally to the transitory regime, because the penalty protection regime applies as from the tax period following the one in course at the end of 19. So basically, starting 2020 onwards. And for the tax periods prior to that one in course on the 29th of December 2023, the deadline for preparing the documentation is June 2025, but we have some uncertainties about the effective deadline. This is because it's not clear from the legislative framework and by the circular letters issued up to date by the tax authorities, which is the exact date. Taking a conservative approach, the deadline should be the 6th of June 2025. This is subject, let's say, to confirmation from the tax authorities. We do not have up to date, and there are also some rumors, but also in this case without any certainty about a possible, let's say, extension of the deadline to October 25. But this is something to be confirmed and to be that, let's say the Italian tax authorities should, let's say, be clear on this before taking any position. In general terms, this is valid for the tax years from 2020 to 2022, because for year 2023, you should prepare the documentation and file it by the deadline for the tax return expiring October 25, and for the following year, already told with the, let's say, ordinary term for the preparation of the for the filing of the tax return. Okay, now I leave to Serena the following part of the presentation with, let's say, discussion about the direct hybrid mismatches. Thank you very much.
Thank you, Guido. Yeah, now we are going to analyze and to understand something more. We'd refer to mismatch from direct hybrid. As already said by my colleagues, the fact that there is a penalty protection regime prescribes that a specific documentation with a specific structure should be prepared. And as already said by Guido before, apart the timely communication and the timely preparation of the documentation, you need also to include in the documentation specific issues, specific description. But what kind of analysis shall be included in order to have the penalty protection? And what does it mean to analyze the direct hybrids? First of all, it needs to understand what is a direct hybrid. And as already told by Guido, you need to investigate if all the elements specified by the decree are met. So the subjective element, the hybrid case, and the deduction non-inclusion or the double deduction effect. With reference to the subjective element, we are preparing the hybrid documentation for an Italian taxpayer. And so the subjective element is verified when the Italian taxpayer is the payer, the investor, or the payee. And in case the Italian taxpayer is the payer, it means that the costs incurred in respect of other group companies or PE are deducted from the taxable base of the Italian taxpayer. In case the Italian taxpayer is the investor, it means that the Italian taxpayer has relationships and participation in an hybrid company, a foreign hybrid company, or with a PE. And so there is, in case of the relationship within an Italian investor and a foreign PE or a foreign hybrid company, there is a mismatch in terms of qualification, tax qualification of the company, of the foreign entity. So the hybrid company is not considered from tax purposes in the same manner from the Italian investor and its state of jurisdiction. So in one state is transparent and in the other is opaque, is relevant for tax purposes in its jurisdiction. And in case the Italian taxpayer is a payee, it means that the positive income component, so basically an income, is attributed or incurred by the Italian taxpayer or is attributed to the Italian taxpayer based on the jurisdiction of the payer. And it means that basically the transaction between Italy and the other group companies involved again an hybrid company. So there is again a mismatch of tax qualification. So basically, by summarizing, which is really relevant on the subjective element is the fact that the transaction incurred by, so there are intercompany transactions between the Italian taxpayer and other group companies, and particular attention should be done when these transactions incurred with hybrid companies and with permanent establishment. So the subjective elements should be met. The deduction, non-inclusion, or the double deduction effect, you need to verify if it is met in a specific transaction. And as last part of the analysis, you need to verify if the hybrid case is actually met. And the hybrid case is not a general asymmetrical tax treatment, but it is referred to this asymmetrical tax treatment that are specifically identified by the legislative decree that have implemented the ATAD directive. So basically, it does not mean that any general asymmetrical tax treatment generates a direct hybrid, but you need to verify if the cases of the legislative decree are met. According to the decree that has introduced the penalty protection regime in Italy, the relevant transaction that you need to analyze for direct hybrid in the documentation are not the only transaction that for which all the three conditions are met. But the relevant transaction that you need to describe in your documentation are the transaction that for which at least one of the three conditions are met. Basically, it is enough to verify the subjective element and be practically the fact that there is an intercompany transaction is a condition that is sufficient to identify the intercompany transaction as a relevant transaction according to the decree. And so a relevant transaction that shall be described in the documentation. For sure, the decree, it does not mean that every intercompany transaction that is incurred shall be included, analyzed in the documentation. But it means that if you are not going to analyze a specific transaction, so you are not have the penalty protection on that transaction. And the penalty protection is only limited to the transaction that you duly analyzed according to the structure of the decree in your documentation. It means so that basically also if you have not an issue of hybrid mismatch, you can potentially prepare the hybrid documentation because according to the structure that the decree prescribed, you need to describe the procedure to identify every relevant transaction. And you can conclude, because it's not forbidden, you can conclude for each transaction that no hybrid case exists. So basically, even if the first condition is met, so there is a subjective scope, and maybe it could happen also the second condition, so you have a double deduction or a deduction without inclusion effect, but you miss the hybrid clause. And if you miss the hybrid clause, and so you are not met the conditions that are specified by the legislative decree, so you have no hybrid mismatch according to the decree, and you can conclude that there is no hybridity for your transaction. And so the question is, why should I prepare the documentation if I have not the issue and if I know hybridity for my transaction? Basically, because as already said before by my colleague, the Italian tax authorities has a very aggressive approach, and we are experiencing many cases in which the position is not clear as usual, white or black for sure, but here we are in a gray zone. And because the amount in discussion are quite huge, we suggest to prepare the documentation just in order to have the chance to say, okay, this is our position. This is why we are not, we are not in a position to have an hybrid mismatch, but anyway, we have the penalty protection guarantee. The documentation that you need to prepare for the penalty protection regime prescribe a specific section, which is section number 3, which is fully dedicated to the procedure. What about the procedure? The procedure is the, logic process that you need to follow, you declare to have followed in order to identify all the relevant transactions. So the transaction that we speak before, the transaction that met, for example, the subjective scope, and that I decide to analyze one by one. So in section number 3, I declare which is the procedure that the group or the company followed in order to identify all the relevant transactions. This procedure is quite detailed because the Italian tax authorities put all the details, a very long list of the details that you need to verify in the Appendix B of the decree that they published. It's a very detailed list, and it is assumed that you need to verify for sure the content parties involved, the tax treatment of the negative income components or positive income components, the tax qualification of all the content parties included, and other, very detailed, also with regard to any CFC regime applied, or, for example, the any neutralization of the hybridity if identified that you have put in place. The fact that it is given the opportunity to the taxpayer to prepare the documentation for the fiscal year prior to the entry to force of the decree allows the taxpayer to have a soft procedure in place, just because it is something that you need to put in place in some months for previous fiscal years from 2020. And so it is something that could be a little bit softer with regard to the previous fiscal year, without that the fact that the procedure is a little bit lighter, without that this fact affect the penalty protection regime. But anyway, it is something that you need to declare, even if it is something more simple, you need to declare to have followed. For sure, for the direct hybrid, because of the subjective scope that we have, which we have spoken before, the starting point is quite, for the analysis, is quite simple, because is the intercompany transactions incurred by the Italian taxpayer with the other group companies. All the intercompany transactions, because many times the doubt is that, okay, I can focus only on the negative income component without including the positive income component. The answer is yes, you need to focus on all the intercompany transactions, just because you need to analyze both the double deduction or deduction non-inclusion effect for all the income components. And in case of positive income components, the risk is not only that the Italian taxpayer has not included in its taxable base the positive income component, but there is something referred to the relationship with the hybrid companies or foreign PE that could consider the Italian entity as the beneficiary company, so that the positive income component is incurred by the Italian company, but the Italian company has never incurred such or realized such positive component. So due to the mismatch of the tax qualification, the investigation and the analysis should also be done on the positive income component incurred by the Italian company, or that should be incurred according to the legislation of the payer by the Italian company. In this sense, the analysis of the direct hybrid is quite simple in respect of the analysis of the imported hybrid, because the starting point is quite clear and there are all the intercompany transactions. And in case the Italian taxpayer has already prepared the transfer pricing documentation, for sure the information that have been already included in the transfer pricing documentation could be taken as a starting point in order to prepare and to start the analysis on the hybrid. And for sure, for any transaction, you need to verify the deduction, double deduction effect or deduction non-inclusion, and then the hybridity cause. In this slide are summarized the basic information that should be done in respect of each transaction, also according to the Annex B, which includes the procedure that, according to the tax administration, every taxpayer shall follow in order to identify and analyze the relevant transaction. So the nature of the transaction, if it is a cost, if it is a positive income component, if it is a sale of goods or provision of services, financial transaction, interest payment, etc. The counterparties and the relevant tax qualification, the tax treatment of the positive and negative income components. If the component is attributed to a PE, if the relationship, and so the counterparty, is a hybrid company or not. Also the application of the tax consolidation scheme are relevant, and also the quantification of the mismatch if you identified the mismatch. So I give the floor to Paolo Arginelli that can introduce you the description and information that needs to be included in the documentation for the imported hybrids.
Thank you, Serena. Here we are. I will deal with two subtopics. One is indeed cases of imported mismatch arrangements and hybrid mismatches that are imported into the Italian territory, and therefore might lead to the need to apply the anti-hybrid legislation. And later on, I will also deal with the basic content of the documentation. For that documentation to be in line with the requirements provided by the ministerial decree, and therefore being capable of ensuring that the taxpayer might benefit from the penalty protection regime. But let's start from the imported mismatches. So first point is that we do have an important mismatch only when we do have an Italian taxpayer, might be a resident company or an Italian permanent establishment, incurring a negative item of income, what in the documentation that was developed, I would say almost 10 years ago by the OECD, was called the imported mismatch payment, that finances directly or indirectly a hybrid mismatch that is occurring abroad. So a hybrid mismatch that is occurring between two foreign jurisdictions. And in that case, so if we do have a hybrid mismatch abroad and an important mismatch payment by an Italian taxpayer to a foreign entity, typically a foreign entity of the group, then we might have this effect of importing the hybrid mismatch in Italy. And the impact would be that the Italian taxpayer is not allowed to deduct the negative item of income unless there has been an equivalent adjustment in the foreign jurisdiction. We thought that could be useful for you to understand is to see how, according at least to the revenue agency in Italy, we might have imported mismatches. Because, well, you will see there are at least two cases that are not infrequent and that are peculiar of the approach taken by the Italian revenue agency to importation of hybrid mismatches. So we are going to present four basic cases that have occurred to us and have been described in the documentation for some clients. And they are, as I said, basic representation thereof, but to give you a bit of the idea on what we are talking about. First case, that's a typical deduction, non-inclusion, imported mismatch. We do have DNI occurring abroad. You will see here ACO and BICO, two foreign entities. There is a hybrid financial instrument that is issued by BICO. According to that, you will have a deduction in jurisdiction B in the hands of BICO, but we will not have an inclusion in jurisdiction A due to the different characterization of the financial instruments by the A legal system. So a DNI mismatch is created, and that mismatch is imported into Italy by this payment. See, the Italian company is making a payment of a plain vanilla financing arrangement, so an interest on loan, for instance. That payment is an important mismatch payment, is financing the foreign DNI effect, and because of that, Italy, and in particularly Itaco, is importing the effect of the mismatch. The result would be, unless there is an equivalent adjustment, typically in country B, if that is not the case, the fact will be that Itaco shall be prohibited from deducting the interest payment to BICO. Here we are obviously assuming that all the companies pertain to the same group. Case two, that's also quite typical case of double deduction, which is imported. So the centerpiece is BICO. BICO is a foreign entity which has a permanent establishment in a third country here. The foreign branch, the foreign permanent establishment of BICO is not under a branch exemption regime in state B. On the contrary, it's profits and loss are included in the general taxable profit and loss of BICO. If the branch is in a loss-making position, that means that the loss of the branch is taken into account. It is reducing profits in the hands of BICO. It's typically profits that are arising from other activities or other assets of BICO. At the same time, that might be included in a tax consolidation system in country A together with fellow company ACO. Therefore, the loss of the branch that might derive from payments made also to third parties is taken into account twice. One in state A and is deducted by ACO under a consolidation tax regime, and in state B in the hands of the head office of BICO. If none of these two countries eliminating actually this effect of double deduction, and Itaco is making a payment that is an imported mismatch payment to BICO, the effect thereof is that Itaco is importing the effect of double deduction into Italy, and therefore Italy is prohibited from deducting that otherwise deductible payment. Case 3, I would say unfortunately quite common for groups of multinational groups of company that are or were active in Switzerland and that have benefited in Switzerland from well-known, at least for some, principal ruling regime, according to which Swiss entities in the past, let's say up to 2019, were allowed to benefit from this juridical fiction of the existence of permanent establishment abroad. The permanent establishment here, this branch, that was generally not recognized as existing by the foreign jurisdiction. The effect thereof in the past was that being Switzerland a country that applies the branch exemption for eliminating juridical double taxation in respect of permanent establishment, there was no taxation of a certain part of the income attributable to this fictitious PE abroad, and this very same part of the profit of the Swiss entity was exempt in Switzerland because of the branch exemption regime. Now, that kind of ruling was terminated at the end of 2019 due to the work of the OECD on substantially aggressive tax planning techniques and tax systems that might lead to some kind of reduction, progressive reduction of the tax rates within OECD countries, to substantially Action 5 of the BEPS project. And because of that, under Swiss legislation, it was allowed Swiss entities to repatriate that fictitious branch with a step up, substantially equivalent of the net effective value of the goodwill stemming from the part of the activities that was fictitiously regarded as being carried out abroad. This branch repatriation, being the branch not seen as a taxable entity in the foreign jurisdiction, was not included in a tax base in the foreign jurisdiction, was not taxed because the branch was disregarded by the foreign jurisdiction, but the goodwill arising with this step-up procedure was typically recognized for tax purposes in the end of a Swiss entity and could be deducted by way of amortization. Now, this creates, according to the Italian Revenue Agency, a case of deduction in Switzerland of amortization of this step-up goodwill and not inclusion in the foreign jurisdiction, the branch jurisdiction. That is also true, notwithstanding the fact that generally this step-up occurred at the end of financial year 2019. which technically speaking and financially that fall outside the scope of application of the ATAD 2 directive and also outside the scope of application of the Italian rules on hybrids. But the Italian Revenue Agency considered that because amortization of the goodwill takes place in following years, 2020, 21, 22, and so forth, that amortization is sort of rejuvenating the deduction non-inclusion effect. If the Swiss entity enters into some transaction directly or indirectly with an Italian company, Itaco substantially is importing the effect of that deduction non-inclusion. Finally, fourth case concerns the US. That's a case where we do have a company of the group here, ACO, which is set up in a state that does not apply any meaningful corporate tax, for example, with corporate tax rate equal to 0 without any corporate tax under the general rules of the tax system. And we do have several examples up to last year. Woodhouse was one, Cayman was also another case. We assume, which is something that has occurred to us as well, that ACO is entering into some licenses with BICO, which is a tax resident of another jurisdiction. BICO is paying royalties to ACO. The royalty is not taxed, 0 tax rate, but the royalty payment is deducted by BICO. Now, if we stop here, we wouldn't have a deduction non-inclusion effect relevant for hybrid mismatch purposes due to the fact that the reason for the non-inclusion in ACO is not a hybrid cause of the transaction, or the fact that ACO is regarded as transparent by a jurisdiction is only due to the fact that country A does not apply corporate tax. However, the position of the revenue agencies that resemble to a certain extent the one of Australian tax authorities in this respect, that if the holding company or the participating company, the investor is a US company, the US company should have applied to the royalties subpart F regulation and regard the royalties as subpart F income. However, if that royalty payment is disregarded because under US legislation, BICO is subject to check the box treatment as transparent, and therefore the intercompany payment between BICO and ACO, this royalty payment, is regarded as if it were an intra-company payment, so irrelevant. Then, under US legislation, according to the revenue agency, you have a non-inclusion because you are deviating from the general rule applicable, that is taxation of the royalty payment under subpart F rules. Therefore, between the 3 countries, and in particular between US and country B, a deduction on inclusion effect is created if Itaco directly or indirectly is financing this deduction non-inclusion arrangement by, for example, acquiring goods that are sold to Italian clients, then you might have an important mismatch. All 4 cases that have just been presented are cases that we have faced dealing with the revenue agency. The last 2 in particular are cases that the revenue agency are pretty interested to look at and deep dive into if they find that there might be cases for those type of hybrids to occur. Now, what does the decree says about penalty protection for imported hybrids? Very briefly, Article 7 provides, different from what Serena told us in respect of direct hybrids, for indirect or imported hybrids, it provides that the benefit of the penalty protection will be available even if only an internal procedure that met the condition and the requirements provided for in Article 3 is described and demonstrated to exist via the documentation. So you don't need to identify and describe specific transactions. All you need to have is a solid internal procedure to identify the indirect mismatches. Article 3 of the ministerial decree, provides for a broad outline of this procedure. So there is a reference framework that we might use in order to structure or review and modify the internal procedure of the group. In addition, the explanatory report to the decree provides that in addition to this general rule according to which the existence of a solid internal procedure is enough to benefit from the penalty protection, notwithstanding the fact that the procedure is regarded as not proper and adequate in order to ensure the track and tracing of the transaction, for those transactions that are specifically described into the documentation, then in any case, the penalty protection shall apply. With respect to the procedure, in addition, the decree provides that substantially the Italian taxpayer and the group more generally should apply a top-down approach. A top-down approach because the Italian tax office of the group should receive the most important pieces of information from the parent's company tax office, from the head office or group tax office. And based on that, it should draw the procedure and provide information within the documentation itself. The top-down approach provides substantially that there is a need central in the group to identify possible hybrid mismatches that arise in forest jurisdiction, quantify those mismatches, identify, if any, the payments made by the Italian entities that might determine the importation of the mismatch. And in that respect, those payments assume relevance according to the general procedure that has been provided by the OECD within the hybrid mismatch arrangement report of 2015. So you're divided between structural arrangement importation, direct importation, and indirect importation. But I will not deep dive into this. And finally, to conclude, what is the content of the documentation? Well, the documentation is substantially made of 4 sections. The first section provides for information on the multinational groups, a description of the multinational groups, a list of the companies of the multinational group, and then it will be the tax qualification of each company, in any case enterprise, of the multinational group, that is transparent or opaque, transparent or disregarded, according to both the law of their state of residence or incorporation, but also from the point of view of the state of their shareholders or investors. And that is due to the fact that revenue agency is willing to know whether there might be certain hybrid mismatches deriving from the different qualification of entities of the group. You have to describe whether and to what extent permanent establishment exists, whether the permanent establishment are recognized by both the country of establishment and the country of head office, and you have to provide some information on the tax consolidation regimes in effect. Second section, you list certain information on the taxable person, that is the Italian taxpayer, so identification data of the taxable person, the residence, which is generally Italian, just Italian. If it's dual resident entity, you have to provide for that. Tax qualification of the Italian entity, that substantially is the same kind of qualification disregarded through tax transparency that we have seen in respect of foreign entities of the group. The recognition of the existence of a permanent establishment in Italy and whether there are permanent establishment of Italian companies located abroad. And finally, you do have the last two sections. The third section, as already Serena provided, is a section that includes a description of the relevant procedures, so procedures for both direct and indirect mismatches. If there are cases or might be relevant, it would be useful also to include specific procedures for other type of transactions that might occur with third parties, in particular structure mismatches, so structure arrangements. And finally, section 4 is a section dealing with the relevant transaction, in the case direct mismatches for sure, if you want also for indirect mismatches, if you want to identify and describe the relevant transaction. Substantially, the content is the one that Serena already highlighted, so you have to describe the subjective element of the transaction, the relevant hybrid mismatch components of the transaction, and you have to analyze with the legal characteristic, tax treatment, and so forth, the transaction that you are describing, and give also a certain limited documentary evidence of the analysis carried out. To conclude, the documentation obviously must be prepared in Italian. Therefore, all the documentation that has been drafted originally for discussion with the group in English must be translated into Italian, must be prepared for each taxable person that is willing to be covered by the penalty protection regime. It's possible that the documentation is prepared by one single entity, Italian entity of the group, on behalf of other companies, Italian companies or PE of the group, but in that case you need to have different parts of the documentation, each part for one different company of the group that is willing to benefit from the penalty protection, and must be signed by legal representative, and the signature must be electronic signature, because the documentation is electronic documentation, and there is a need of a timestamp signature, which means that if it were to be confirmed that, for instance, the deadline for preparing the documentation for financial years, for instance, 2021 and 22 is the 6th of June, then you need to sign with a time-stamped signature the documentation before the 6th of June. I think it's all for this part. So Serena, I give back the floor to you.
Thank you, Paolo. As already said, until now, we have spoken about the structure of the documentation and the form of the documentation. What needs to be included, how the analysis should be performed for each relevant transaction, for direct hybrids and imported hybrids. But it is enough to obtain the penalty protection? The answer for sure is not. As you already know, the regime, the penalty protection regime for hybrid mismatch is very similar to that of for transfer pricing documentation. And also for transfer pricing, you have for sure already experienced that is not a matter only of content of the documentation. It's not a matter of the fact that you met all the structure and the conditions that are prescribed by the decree to prepare the documentation. So each paragraph, or you give the appropriate information. But you need also to respect and to meet the other requirements that are pure formal requirements. And the other requirements referred for sure the communication of the documentation. What does it mean, the communication? The communication is that in order to obtain the penalty protection regime, you need to timely communicate to the Italian tax authorities that you already have prepared the documentation, that you prepare the documentation which is compliant to the structure that the decree prescribes, which contains all the necessary information, that has been digitally signed, and the timestamp is affixed. And if you are not to communicate, if you're not going to communicate that you have prepared such a documentation, the penalty protection regime is not granted. The communication is something that has already happened for transfer pricing. You are going to include the communication in your tax return. There is a specific section in which, as you know, for transfer pricing, you check the box, and for hybrid mismatch, you only insert a code in order to communicate, to say, okay, I've prepared the documentation, which is appropriate, and I'm eligible for penalty protection. If you're not going to do this communication, the penalty protection is not granted. It is the ordinary regime, which is for sure applicable for all the fiscal years for which, for example, for fiscal year 2024, which closed in December 2024, the tax return, the term to submit the tax return is October 2025, and so you can apply for the penalty protection just by checking the box in the relevant tax return and by preparing the documentation within October. But what about the previous fiscal years for which the decree opened the possibility to prepare the documentation and to have the penalty protection? And we refer to the fiscal year from 2020, so by referring, for sake of simplicity, to the solar period 2020 until 2023. For this fiscal year, we have already said that for fiscal year 2020, 2021, and 2022, the documentation must be prepared within the 6th of June, unless postponement will be communicated. But until now, until the beginning of June. The communication of the preparation, of the possession of the documentation will be disclosed in the tax return of 2024, so in October. You will find a specific section in the tax return for 2024, and you need to communicate that you have prepared the documentation for the previous fiscal year. So you have applied for the penalty protection regime. For 2023, it happens the same, and so you have, but in this case, you have enough time, more time, to prepare the documentation for 2023, because you have until the next October. Basically, but the communication is something, so the communication is intended from the penalty protection regime for a separate fulfillment in respect of the preparation of the documentation. And it is a separate fulfillment also in respect of the delivery and the provision of the documentation to the Italian tax authorities. Because when you are going to communicate to the Italian tax authorities that you have prepared the documentation, you are not going to provide your documentation to the tax authorities. Exactly as already happens for the transfer pricing documentation, the tax authorities, in order to get the documentation, shall ask for the documentation of a specific fiscal year. And in this case, the documentation you are going, it is mandatory for you to provide your documentation upon request by Italian tax authorities in 20 days from the request. It means that also for the previous fiscal years, so 2020, 2021, and 2022, you are not going to provide the documentation to the Italian tax authorities, even if it is referred to the previous fiscal years, but only upon request. It is another important issue with regard to the fiscal years previous 2023. The transitional period, so that will expire in June, in order to prepare the hybrid documentation for the previous fiscal year, so 2020, 2021, and 2022, is a period in which you can prepare your documentation even if a tax audit is starting. We have experienced many cases in which during this transitional period, the Italian tax authorities start a tax audit, an inspection, but anyway, because we are in the transitional period, the Italian taxpayer can always apply for the penalty protection regime. I can say to the Italian tax authorities, okay, we are under tax audit for sure, but we are going to prepare the penalty protection, the documentation for the hybrid mismatch, because the law guarantees us enough time to prepare it, and we are going to share with you the documentation and all the information requested within the term and expiring of the transitional period, so within June. It does not affect the penalty protection regime, and the penalties will be in some way will be zero. There are another issue with reference to the appropriate communication of possession of the documentation and the delivery. There is also the possibility that the Italian tax authorities is going to ask further information and further evidences in respect of what you have declared and included in your documentation. And this is something that the taxpayer must provide in 30 days. So the documentation, the hybrid documentation must be provided in 20 days from the request, and the further supplementary information in 30 days. How it affects the penalty protection? I mean, which kind of supplementary documentation could be requested by the Italian tax authorities to the taxpayer? The decree is not precise in that sense, but provided the fact that we have already said there are many similarities for that regime to the transfer pricing regime, we expect that the supplementary information that the Italian tax authorities is going to ask are information or evidences that prove and demonstrate what the taxpayer has included in its documentation. So, for example, in case we said that a specific positive income component is included in a taxable base of the foreign company, the Italian tax authorities could ask for the evidence in order to prove such an information. Or, for example, in order to understand or to expand or to explore further the tax treatment of a certain component or for permanent establishment, for example, or for another companies for which we declare that it is transparent, but we can be asked to prove why it is transparent, or in case we declare that we have applied for certain consolidation regime, the Italian tax authorities could ask something in order to prove that certain consolidation regime has been applied. In case that supplementary information are not provided, it's not specified if the penalty protection is denied or not. It depends on the fact that if the tax authorities link this kind of information to the section of the documentation which is named evidences and which is included for each relevant transaction in Chapter 5, or it is something more extra in respect of the evidences that the taxpayer has already annexed, attached to the documentation. For sure, it's something that we are going to explore in the further months in the discussion with Italian tax authorities, not only for the pending audits, but also for the future audits or future examination of the hybrid documentation. But it's something that for sure will be discussed a lot. I let the floor to Luca in order to speak about the effectiveness of the documentation.
So, thank you, Serena. Okay, just give me also the control of the slides. Very good. So my duty is very simple at this part of the webinar, because most of the elements that I'm just summarize here in the next slides have been already covered by my colleagues. And as you have heard, so a very big importance now there is so in the distinction between direct hybrids now or imported hybrids. And as already either Serena or Paolo said, the difference between so what a direct hybrid is with respect to what an imported hybrid is, as a consequence in terms of type of documentation that have to be prepared, and so the different consequences in terms of the effectiveness of the documentation. Because if we go to Article 7 of the implementing decree, then it clearly states two different points regarding direct hybrids or imported hybrids. And for direct hybrids mismatches, it clearly states that what already Serena said, that the penalty protection is granted, applies only with respect to the transaction described in the documentation, clearly only if this documentation satisfies the conditions and requirements set forth in the decree. So in Article 4, 5, 6, 8, 9. So structure, content, form, delivery terms, conditions of effectiveness, notice of possession. So if all these conditions are met, the transaction described in the documentations are covered by the penalty protection. Serena also said another important point of the fact that if you decide not to disclose some relevant transaction, or in case the representation was certain, so a type of transaction is unsuitable, no, with respect to grant the penalty protection. This does not undermine the effectiveness of the documentation with respect to the other relevant transactions that have been disclosed in the documentation. Clearly, only if, with respect to this latter transactions, the conditions set by the decree are met. So it is also in this decree clarified what has been clarified in the decree regarding the transfer pricing documentation, that so you can decide at least not to cover all the transactions, but and in any case, the fact that there is a transaction that was not, properly described and communicated does not affect the effectiveness of the penalty protection regime in case so the other transactions are properly and correctly documented. That's an important point. And the other, if we go to the imported hybrid, then clearly, as we said, there is a difference in terms of documentation and the type of documentation, supporting documentation that is requested by the decree. And Article 7 consequently states that with respect to imported hybrids, so the penalty protection applies if there is an internal procedure that meets the condition and requirements set forth in Article 3, is demonstrated to exist, and if the documentation clearly meets the conditions set forth in the articles we have talked about, in these 2 hours. So it's a question of documenting the existence of this internal procedure, which for, let's say, general cases has to be in compliance with the requirements that was in Article 3, and therefore, so the appendix or the attachment B of the decree. If we go to the transitional, so let's say period, so a transitional regime, so and if we see what the law states for the tax period prior to that in course on December 29th of December 2023, in this case it is stated that so the penalty protection regime is applicable only if the internal procedure is adopted is suitable to identify possible hybrid mismatches. So what is the difference? The difference is clearly is that for the previous year, the internal procedure may differ from the one set out in Appendix B. It makes sense because for the previous year, we didn't have any Appendix B to rely on, so let's say it doesn't make sense that the penalty protection regime had to be, let's say, linked not to the possibility that this procedure was in line with the Appendix B that did not exist. But in any case, an internal procedure had to be, let's say, proved to exist for the previous year, even if not, let's say, in compliance with what for set out in Appendix B. So I go back. So again, let's say the Article 7 confirms the partial penalty protection in terms we have described before. However, it's clearly stated that the general part in describing the group and the taxable person must be complete and prepared. So you have to be a full, let's say, general description. Then you can, as we said, decide eventually not to cover some specific transaction. Just a few words regarding also Article 8 in terms of effectiveness of the documentation. Article 8 is provides, some indications. So the colleagues have already talked about. There are, mainly in line with the indications for the TP documentation, as I said. And also here it is stated another important point. So the fact that if there is any partial omission or inaccuracies in the documentation provided, this inaccuracies if they do not compromise the analysis of the control bodies of the auditors, so that does not impede the control of the auditors, this does not constitute grounds for preventing the application of Article B in paragraph 6b. So in other terms, so minor omissions or inaccuracies in any case, so if they may, that do not impede the application of the penalty protection regime. And another point that is important from a procedural point of view is that, so if there are, on the other case, let's say, inaccuracies, omissions, or the documentation is not, let's say, partly true, there are missing information, not complete or whatsoever, that may impede the application of the penalty protection regime. In this case, the negative assessment, and therefore the application of the negative, let's say, the non-application of the penalty protection regime must be done by the auditor side. So when the auditors when the audit is finished, so in the processo verbale di constatazione, as we call, and has to be specifically motivated and grounded. But in any case, so those who at the end of the story have the possibility to apply or not to apply the penalty protection regime is the competent office, so the assessment office, which retains the power to critically assess the judgment given by the auditors in his tax report, the tax report. So indications again of the decree that are completely in line with the indications that are for the TP documentation. Nothing more to say apart the fact that Article 7 provides another important point that I'm not talking about, because I will leave the floor to Paolo to discuss about this, is the fact that in Article 7 there is also specific reference in terms of effectiveness of the interaction, let me say, between this penalty protection regime for the hybrid mismatch and cooperative compliance, and companies that are in a cooperative compliance regime. But I will not say anything about that because I don't want to leave the floor to Paolo, and I leave the floor to Paolo to talk briefly about this point at the very end of this presentation.
Topic to be discussed is the relationship between the penalty protection regime and cooperative or collaborative compliance regime. As you know, Italy has implemented for almost 10 years now a very successful cooperative compliance regime, and obviously the decree could not disregard this important regime that many companies with the multinational groups adhere to in Italy. And therefore there are some rules, in particular in Article 7 that was already cited by Luca on the one hand, and Article 12 on the other hand of the decree, dealing with this interaction. Substantially, there are several rules. The two are the most important. The first one is that the decree specifically provides that for companies that are under a cooperative compliance regime, the documentation that has been drafted according to the regime in order to get the penalty protection from the setup and signature of the documentation constitutes a fulfillment of the obligation of reporting and transparency that are placed on those entities by the regulation of the cooperative compliance regime itself. Therefore, that's why we generally say, although technically it's not proper, but as a matter of fact, that's quite close resemble realities, that companies that are under a cooperative compliance regime are substantially obliged to set up a documentation, because that documentation is necessary in order to be aligned with the reporting and transparency obligation under the cooperative compliance regime. A second point, that for those companies, there is a distinction that is highlighted by the decree between transactions that are below a certain materiality threshold and those transactions that are above the materiality threshold. The materiality threshold is determined by discussion with the revenue agency for those companies that are already under the cooperative compliance regime, as long as that materiality threshold has not been set by the revenue agency. The general materiality threshold of the cooperative compliance regime is taken into account, and the materiality threshold for the hybrid mismatch documentation and for penalty protection purposes is set at the level that is equal to 1/4 of the general materiality threshold, 1/4. And one that distinction is made between transaction above and below this materiality threshold, the decree provides that for transactions that falls below the materiality threshold, it is enough in order to get the penalty protection and update of the tax risk matrix, which is the basic matrix that is sort of the centerpiece, or one of the centerpieces of the cooperative compliance regime itself. These are the two most important rules. Obviously, the second ruling directly makes it clear that for the transactions that are above the materiality threshold, is necessary in any case to set up the documentation for hybrids, and therefore all the rules that have been discussing up to now must be complied with. And finally, there might be also the need to remember that if you are under a cooperative compliance regime, your internal procedure should cover both direct and indirect hybrid mismatches, but should also cover the possible identification of structural arrangements, so arrangements that make a transaction relevant for hybrid purposes, also if that transaction occurs with third parties. That said, we see that there is a question in the Q&A section. The question concerns Italian real estate investment fund. Substantially is asking whether Italian real estate investment funds are obliged to prepare the hybrid documentation for the penalty protection. And I don't know, I can give you a first possible answer, and then the colleagues are gonna discuss it further. But substantially, on the one hand, there is no obligation. There is generally no obligation for any company. Technically speaking, not even obligation for companies that are under cooperative compliance regime. So certainly no obligation for Italian real estate investment funds. There is an opportunity to file, to prepare the tax documentation for hybrids. I would say, based on experience, generally not. Obviously, it would be better to see each specific case, but since Italian real estate investment funds are, although opaque taxpayers, they are exempt. Generally, their involvement in transaction do not lead to any hybrid mismatch effect. So no double deduction, no deduction on inclusion. That statement would not be correct. However, if we look at investment structure, investing in real estate that are using different kind of vehicles, like, for instance, ordinary Italian company vehicles, because in that case it is possible that hybrid mismatch arrangements arise from the transactions that are carried out by those vehicles. Certainly, foreign investment fund or generally foreign investment vehicles might be and should be taken into account because they might lead to hybrid mismatch arrangements. The second one is, how is a group with 540 companies and 15 branches around the world with more than 1.2 million intergroup transactions per year, that is the part that they are aware of, are going to be able to do this exercise? Well, certainly, I would say it's extremely difficult exercise. We have some clients groups that have similar dimensions. I have at least a couple in my mind, and clearly it takes a lot of time. It takes a lot of time, and what is useful at least is that for indirect hybrids, that I would say they generally represent some 80–90% of the risk in Italy, that having a solid procedure is enough to get the benefit of the penalty protection. So you don't need to give disclosure of all potentially relevant transactions if the hybrid mismatches are indirect. And I would say it's generally very difficult that the transactions that are directly put in place by the Italian entity by themselves trigger hybrid mismatches. But, well, I agree on the fact that it's clearly a very time-consuming effort, in particular for preparing section 1 of the documentation, that is mapping all the group and mapping the tax qualification characterization of group companies, transparent or opaque. Although I have to say that similar kind of exercise is also due for Pillar 2 purposes. Therefore, is something that is unfortunately becoming more and more common. There is a question asking whether there are templates for questions to be sent out to the group companies. Well, templates are templates that are to fit with the procedure of the group. We internally have developed some, say, basic templates on the basis of the structure of the documentation proposed by the revenue agency and our experience. Those templates later on must be reviewed and changed and under discussion with the central tax office of the group based on the characteristic of the group. But yes, there are templates that are, I would say, most of the Italian law firm have or should have created in order to make life easier for the clients. And templates for the report as such, yeah, the basic template of the report is provided by the revenue agency. So the structure of the report is substantially prepared by them. Then there is a question, I don't know, Guido, if you also want to give your view on that, because I know that you have also dealt with this kind of cases before, is the question in case of commissioner models, no mismatch since no deduction, would you submit documentation if it's a proper commissioner and if there is no other kind of relevant transaction? The answer would generally be you don't need to have it because you don't have any negative item of income deductible in Italy. Certainly, it's a matter of a case-by-case analysis. If you have a buy-resell transaction, so you have a distributor or a permanent establishment acting as distributor, that's a different subject matter. There is something that has not popped up yet. Hopefully, I hope and I think that it will not pop up in the future. but you know that Italian revenue agency is quite aggressive in trying to see permanent establishment of foreign entity existing whenever the sale of the Italian territories is carried out, the transaction are carried out by a commissioner in Italy. So question would be, what does it happen if the revenue agency first, during a tax audit, find assess existence of a hidden permanent establishment as distributor, and second step is disqualify the permanent establishment from deducting the cost of acquisition of the goods because of a hybrid mismatch? That technically, in theory, is possible. You will need to have very, very smart tax officers, and that also are pretty bad in dealing with the taxpayer, because it would be a double burden, extremely significant for. I don't know if Guido, it never happened to you to see this kind of scenario. So the one of the commissioner.
Yeah, Paolo, the point is that, as you told, Paolo, I agree with you. The point is that if you have a genuine, let's say, commissioner without any, let's say, parallel audit activity by the tax authorities aimed to qualify as buy-sell distributor rather than commissioner, then there would be no need for an anti-hybrid documentation. Otherwise, if the tax authorities, let's say, doing their analysis based on, let's say, documents available also about the foreign entities of the group involved in the transaction, find the possibility, let's say, to address an anti-hybrid audit or issue in Italy, then I think it would be for them possible, or they could try to, let's say, assess in a different way the commissioner and requalified as a distributor, and then try to apply also the anti-hybrid rules. And so you have, let's say, two separate but with huge effects audits in terms of requalification and then hybrid application of the Italian anti-hybrid rules. We did not experience such a position up to date, also because the anti-hybrid rules are quite new, let's say, or better, the Italian tax authorities did not address these type of positions, but anyway, we could also expect such a position. I see that there is also another question that is very interesting, because it's true that it's not easy to let the financial managers understand what an hybrid mismatch is, and it is difficult to understand how to address this topic on a global way through an M&E group. Answering to the question, I think that it's possible to try to let them understand with some, let's say, simple examples how things works in this respect. And about the understanding from the Italian tax authorities how companies works in practice, I can tell you that in the last few years, the central offices of the Italian tax authorities gained a good understanding on the tax structures outside Italy and how they are managed by M&Es, and they go straight forward. Some, let's say, of them that could be relevant. We experienced this with both the Milan office of the tax authorities, but also with the tax police that is very aggressive in this respect. They look at publicly available data also from the US due to the SEC filings requirements, and based on that set of information, they try to understand more and go deeper into details about how things work. Coming back to the question, I think that a session with the financial managers, by providing them with a simple example, could help to let them understand which is the problem and how the problem can be handled.
Yes, if I may, I would add that it's true that the most relevant difficulty in multinational groups is to make this kind of issues be understood by local tax manager or finance manager. However, it is also true that, at least in my experience, we'll say in our experience, more than 90% of the job is carried out by the central tax office of the group. I think the additional information that the central tax office has to ask and require local tax people or accounting people within the group to provide is rather limited, and it does not generally require the local tax and accounting people to have a deep understanding of the functioning of the rule. What the revenue agency is given for granted, but that is not a problem only of our revenue agency, it's a problem of the rule itself, of the set of rules themselves, is that if a hybrid mismatch occurs, it is generally considered that at least the central tax office of the group is aware or was proactive in setting up the structure. So it should be able to find the relevant information and provide it to the Italian tax director or tax manager. That's a line of reasoning behind the penalty protection regime, but it's also the same line of reasoning that is behind the OECD project. I mean, the sin, if there is any sin, is to be found within the hybrid mismatch rules that were devised by the OECD some 10 years ago. That's my view, at least.
I think we ran out of time, so we're almost on time. So I don't see any other questions. So so I would like just to close, and so thank you first of all, you all for having spent this couple of hours with us, so talking about this very tricky argument. Let me say thanks my colleagues for the presentation they have done. So very clear and complete. So we remain at your disposal for any further questions, information you might have. And last but not least, let me remind the service information that I made up at the very beginning. So slides will be available on the website. So the video recording will be available on our YouTube channel. And that's it. So thank you all, and good afternoon, everybody.